Legal from Burlington and Rockenbach on behalf of the appellant. I'd like to reserve 5 minutes of my time for rebuttal if I could. The trial court here compelled arbitration in direct contradiction to a Florida Supreme Court case holding that arbitration could not be compelled where there were provisions such as what we have here. And the two specific provisions are provision capping non-economic damages at $250,000 and prohibiting an award of punitive damages.
Would you say this case is directly that the estate of Yetta Nuvista is directly on point?
I do believe that that case is directly on point. Obviously, it's not controlling on this case, but that case had the same two provisions, and there was a severance clause, which was the distinction between the Florida Supreme Court case Gessa. And the court there addressed that and said that Gessa was still controlling, applied the test, applied basically this, made the exact same findings as the Florida Supreme Court in Gessa, and denied or reversed the order compelling arbitration.
But in Gessa, there was no severability clause.
Exactly, you're right. There was no severability clause in Gessa, but what the court did in Gessa is use the same exact test that it had used in Schatz, which was decided on the same day, and essentially said, the court said in Schatz, the existence of a severance clause is not dispositive. And the court said, you know, that Schatz was the first time that the Florida Supreme Court has specifically addressed whether severance was required when specific provisions of an arbitration agreement were found to violate public policy. And the court started out by going through a whole plethora of DCA cases that sort of found different ways. Some of them, you know, if there was a severability clause, that was it. The provisions could be severed and the case went to arbitration. Some of them were applying the general contract principle, which is what the court ultimately ended up adopting in Schatz, which says if the provisions go to the essence of the agreement or the heart of the agreement, then they can't be severed in the arbitration. They can't compel arbitration.
In Schatz, they said a contract is indivisible where the entire fulfillment of the contract is contemplated with the parties as the basis of the arrangement. But doesn't the fact that there's a severability clause kind of counteract that? Saying if there's a severability clause, then apparently the entire fulfillment of the contract isn't contemplated, or it's desired, but they have an escape clause.
And the court in Schatz said, in Schatz there was a severability clause, and the court said that's not dispositive. We're going to look at this test. We can't, and I think that if the court was going to apply that test to just say, well, if there's a severability clause, you can still arbitrate. You know, we'll get rid of whatever provisions, but all you guys really want to do is arbitrate, so we can let you go to arbitration. The court in Schatz wouldn't have come to the conclusion it did. It wouldn't have applied that test.
They were only talking, I mean, when they said, this is why we think the severability clause doesn't apply, they looked at what rules applied, and they said, you know what, if you throw those out, we're going to have to start from scratch. We're going to have to, the trial court is going to have to rewrite the rules. Therefore, they are the essential part of the contract, because without those rules, we don't have anything in the contract to govern these proceedings.
That's correct.
Now, that's not true in this case.
That is not true. But the court's decision, it's not extensive. We're not dealing with the AHLA rules, which were applicable in Schatz. The court's decision in Gessa made very strong findings that provisions, the limitation of liability provisions at issue here, they said, the financial heart of the agreement. And the court said it would be a trial court would be hard-pressed to conclude with reasonable certainty that with the illegal provisions gone, there still remains of the contract valid legal promises on one side, which are wholly supported by valid legal promises on the other.
Well, but
and that was on these same two provisions. And I'm sorry.
But I don't know whether Gessa is exactly like this, because the provisions here, where they're limiting liability, say economic damages, non-economic damages capped by such and such. What was C? Interest, and D was punitive damages. And then right after that, it says a second severability clause. They said if any of those are invalid, the rest of them, it's okay. The rest of them prevail. So how can you say that that's the heart of the agreement when in the agreement the parties are saying you can throw them all out and it's still okay?
Because in the agreement, they also highlight specifically, which is not the case in any of the other opinions, including Gessa, including from the opinion in Nuvista, and none of the other cases cited by the defendant have this subsection B, where they highlight the importance of these limitation on liabilities and essentially say this goes to the essence of our agreement. I mean, that's what this sentence says. I mean, that paragraph is saying this is why we're doing this. I'm going to just read one sentence here from that. The parties' decision to select arbitration and to agree to a limitation of liability are also supported by the potential benefit of preserving the availability, viability, and insurability of a long-term care company for the elderly and disabled, by limiting such long-term companies' exposure to liability. So they've got an entire paragraph explaining that the whole purpose of the limitation on liability and the arbitration agreement is to limit liability and to save costs and time in the procedures.
So what you would say is that the limitations on liability alone, not I think you also challenged a couple of the other provisions.
Yes.
But those in and of themselves, if you've got that and you have in this case, because you have this other contract provision, Section C, that it shows it's the essence and therefore it's, the severability clause can't save it.
Yes, and there's also, if I could also note, and this is identical to GESA, the court in GESA highlighted, there was a sentence, it was set up the same way, except there was no subsection C. Subsection A was arbitration, subsection B was limitation of liability. In the first sentence in GESA, which is the first sentence here, says, of subsection B, the parties to this agreement understand that the purpose of this limitation of liability provision is to limit in advance each party's liability. So the court in GESA focused on that one sentence in saying that these two provisions went to the financial heart of the agreement. We have here in addition to an entire paragraph explaining the importance of these provisions to the entire agreement here, to both arbitrate and to limit liability.
Is it fair to say it's a dual essence, which I think, didn't you guys use that in your brief? Called it a dual essence?
Dual essence?
Like, they wanted to limit the damages, and at the same time they wanted to set the process.
You're right, and they also wanted to limit not only damages, but costs and time saving. And all of that, especially when you factor in the other provisions, which other courts, including this court, have found, several of the other provisions violate public policy. If you take all of those out, you really are wiping out not only the liability limitations, but also some of the other time and cost saving efforts.
Well, isn't the real thing here that you avoid a jury? I mean,
well,
that's the thing that's bolded. That's the thing that's bolded all over.
But that's the case in any arbitration agreement, and so we could
because
never
it's more
find
expensive to go in front of a jury.
Yes.
The estate of Deresh.
Yes.
Okay. In that, we're dealing similar. Now, they had just the punitive and not the non-economic. But apparently, from what I'm reading in the opinion, they must have had something like a subsection C because they say the primary thrust of the agreement is, quote, to avoid costly and time-consuming litigation. And then says striking the punitive damage limitation would preserve the forum and the finder of facts so central to the agreement. And if it's preserve the forum and the finder of facts so central to the agreement, if that's what we're really saying here, then the fact that you limit the damages aren't necessarily central. I guess it's what's the core essence here. And as I say, I'm still concerned about the fact that in all of these cases, when they talk about this, they talk about trial courts rewriting the agreements, which you don't have to do here.
No, but again, in GESA, the court laid out how important and how these two provisions are the essence of this agreement. And so I think it would be, while we have a severability clause here, if the test is the same and this court had to write an opinion, I don't know how you could write an opinion saying the essence of this agreement is different when you have the same exact two provisions and the court has laid out very clearly and expressly that these go to the heart of the agreement, and that it would be hard pressed to a court would be, what I think the language was, hard pressed to essentially say that there remains any contract valid legal promises on either side. So I think that holding or finding by the Supreme Court is determinative, or it is controlling on the issue of whether these two provisions go to the heart of this agreement.
Would you agree that a severability clause is designed to save what can be saved in an agreement if some part of it is found invalid.
Yes.
Whenever then in any of these kinds of cases is a severability clause ever going to save the agreement?
And that's the test. I mean, and the courts have said again and again, it's not dispositive. It's a factor that can be looked at, I think, but it's not going to save it. The courts applied the same test in Schatz as it applied here, and the court didn't really focus on the severability clause at all, or excuse me, in Gessa.
What if there had only been a limitation on punitive damages and not a limitation on the other types of damages?
Well, that's a perfect example, and that was Duresh. That was the case in Duresh, and the court said the severability clause can save this case because there's just one provision. It's just the punitive damages. This court noted that punitive damages are not awarded as of right, and they're not normally, they're very rare normally, so this really wasn't going to affect a lot of cases to strike out just that provision pursuant to the severance clause. And the court in Duresh distinguished Gessa by saying that these two provisions together may, violate the essence of the agreement, but nothing in Gessa or Schatz says that one of them taken alone. So this court in Duresh recognized that just the one element could be stricken, but once you got into both of these, that Gessa, held that these two provisions together, and said the court's decision said when viewed jointly, go to the essence of the agreement. So this court, that's your situation. That's exactly what happened in Duresh. It was one clause. It wasn't like the court noted, it wasn't something that was going to come up in every case. It was a minor part of a case because punitive damages don't even come up.
So is the test really whether the parts that violate public policy are so great that it really vitiates the agreement, or is it that the court would have to rewrite the agreement once that provision is stricken? What is the proper test?
I think it's the former, and that's what the court laid out in Schatz. And I can read you the test from Schatz, but it was sort of twofold. It was one that goes to the provision, or provisions go to the essence of the agreement, but then the court goes on to explain where the illegal portion is eliminated, there still remains of the contract valid legal promises on one side, which are wholly supported by valid legal promises on the other, then severance is inappropriate, because you still both sides are maybe both getting the benefit of the bargain. They both, you wipe out one provision. Several courts have found that the provision alone, the punitive damages from this court, but also other courts have held that the provision precluding an award of attorney's fees by itself can be stricken, because that doesn't go, it's not as big of a deal, I think, as when you combine these two, the limitation of liability and the punitive damages. Because, and what the court said in Gessa is, once you've taken out both of these things, which are the financial heart of the agreement, you really don't know that there's that same agreement that everybody sort of agreed on anymore. It's so big, and it goes to the heart of the agreement, that it's not the same contract anymore. So it's not necessarily that the court in Schatz obviously, said we'd have to rewrite this whole agreement, but that's not the test. The test is whether it sort of gets to the heart of everything.
Yeah, but getting back to the quote that Judge Warner quoted from State of Duresh, where they said the primary thrust of the agreement is to avoid costly and time-consuming litigation. If an entire subsection still exists, the arbitration clause, can't that standing alone go meet that test?
Well, these two were incorporated together, which is, it was a distinction from some of the other cases, and a distinction from what defense counsel argued to the trial court here, is that these two provisions were incorporated into each other. And we're also arguing that several provisions of the arbitration agreement, and we're not just arguing, the courts have already found that several of these provisions violate public policy and would have to be stricken as well. So it's not just these two, but when you add in the attorney's fees and the waiver of the right to appeal, which are both in the arbitration agreement portion, and you take all of it together, especially when you take all of it together, that goes to the heart of the agreement.
I'm sorry, did the trial judge make a finding as to that this was of the essence of the contract?
No, the court found that, oh gosh, I forget exactly what the court, the trial court found that you could sever them, and that he didn't make any findings that this doesn't go to the heart of the agreement or not. He said that there's a severance agreement. He also found that they were two separate paragraphs, and didn't recognize, and I think because defense counsel argued that they weren't, incorporated into one another. So that was the court's basis, they're two separate paragraphs, so you can get rid of one. And
Is that the case in Schatz, or in Gessa rather?
Gessa, I don't recall. And Gessa, what was argued to the trial court, is that what you're?
No, whether there were the invalid.
Oh, yes, I think there were two separate provisions, because the court talks about the headings under subsection A and B, and I'm already over my time, so thank
I'll
you.
give you a couple minutes to respond.
Thank you.
May it please the court, Dinah Stein on behalf of Applee, Chatsworth at Wellington Green, and we contend that this court can affirm the trial court on several bases, one being which was the trial court's basis for his ruling, which is essentially the Buckeye Rent-A-Center opinions from the U.S. Supreme Court, which interestingly enough, this trial judge was keenly aware of because he was the very judge who was reversed by the U.S. Supreme Court in Buckeye. So he was very attuned to the argument with Buckeye, which is essentially that where you have an agreement, and we contend that our agreement does have a provision that says any and all claims or controversies arising out of or in any way relating to this agreement or your stay at the community, and including disputes regarding interpretations of this agreement, shall be submitted to binding arbitration. So what the U.S. Supreme Court has told all of the federal courts and the state courts is that when the challenge is to an agreement as a whole and not just the agreement sending the case to arbitration, that is something for the arbitrator, and that's what this court found. And the plaintiff did not, nor could they, frankly, challenge the actual validity of the arbitration agreement below, other than the severability portions, but not the delegation clause.
They both courts in Gesa and what's the name of it? Schatz. I keep forgetting. Kind of said that Rent-A-Center, the Jackson, didn't apply, and it does seem to me that it's when you're talking about violations of public policy that those should be delegated to the arbitrator, and certainly, and I think Schatz, they said, no, this is for the courts to decide. We're not delegating something like that, whether a public policy argument, to the arbitrators. Because quite frankly, it's not for the arbitrators to determine what public policy is.
Right, and I think that's why this court below took that into his own hands as far as what the Supreme Court has already held and said the arbitrator's not going to redetermine this issue. The difference in Schatz and Gessa as far as the delegation argument is the language, and of course you have to go to Polston's dissent, but it's very elucidating that you can see the language doesn't say any and all cases or controversies arising out of this agreement. It's cases or controversies or whatever the language is, disputes arising out of your stay, which is much different. And in that case, the court held this is not a Rent-A-Center Buckeye situation, and so it does go to the court. So that is a very significant ground for this court to find that the trial court below did the right thing. He would not let the arbitrator redetermine public policy that has been decided by the Supreme Court, but the rest, he said, this is going to arbitration, where the arbitrator can decide the rest of this.
The order just seems to deny, or the order doesn't have all this detail in it that you're talking about.
And I'm going from the transcript, which is part of the plaintiff's appendix for the initial brief, and I think it's towards the very end of the transcript where he talks about Buckeye. It's not entirely clear what he's sending to the arbitrator. He says, the arbitrator's not going to decide limitations on damages because that's a done deal. He said, no Florida decision has held that this discovery provision is against public policy. He said that without deciding and then sent the rest to the arbitrator. Now, even if the court didn't get to the Rent-A-Center Buckeye analysis, then we go to counsel's analysis, which is pure and simple severability. And this 15-page agreement has no less than 3 severability clauses, not only severing even each provision of the damages, as Your Honor pointed out, as far as if punitives are coming out, the rest comes in, But not only that, but as to subsection C, which is what counsel's referring to on the alleged essence of the contract, first of all, we did find, in addition to the Duresh case, there is one Eastern District of Kentucky case which cited the same language and was very nonplussed with it as far as determining that a case could be severed. But even on this contract, the contract is very specific as to subsection C, which is what counsel is saying is the so-called essence of the contract. And on, I think this is appendix page 47, the contract says, should any of subsection A, B, or C provided below, or any part thereof be deemed invalid, the validity of the remaining subsections or parts thereof will not be affected.
Wait a minute, where are you reading that?
That is from, it's the initial,
That's the initial section.
the initial brief appendix, page 47, which,
Right.
yeah,
Actually,
wherever
it's not
the.
47. See, this is my little pointer for doing these briefs. So
We,
he knows.
we will accept all pointers.
PDF, use the PDF citation page, not the page of the appendix, because they, for instance, you have A47 where it's PDF 49 here, so.
That is very good to know on both of our behalves.
And as a matter of fact, we, as of October 1st, I think there are all new rules with respect to appendices, and
The
follow
email
them,
went
or
out.
otherwise your
Yes.
appendices are going to be stricken.
You touched a nerve, in other words.
No, the email went out today. I reviewed it while sitting in the lounge, and I'm sure both sides of this will duly follow it to the letter.
Okay, so should any subsection A, B, or C, or any part thereof be deemed invalid? But of course, we're not deeming, nobody said C is invalid, so C is there.
Correct. C is there. C, the severance position shows what the intent is of the parties, and that is C is not intended to create any kind of binding essence that everything has to be in here, because we've already said in subsection B that any of these A, B, C, D provisions can be taken out. It says at the beginning, yes, Your Honor.
Let me ask a question, because yes, you're right. B says you can eliminate any of these limitations on liability, and it's all going to be okay. We don't care.
Correct.
In other words, we'll sever those out. But C says limitations on liability are the essence to try to get better care, preserve care in Florida. Now, they're somewhat in conflict. So the question is, should there be, is this something we can decide on the face of the record, or should somebody have taken some, how would you decide this if they've got two conflicting provisions?
Well, I think it's easy, Your Honor. First of all, subsection C, we may be borrowing the word essence. I know it talks about the importance of arbitration, how it benefits people, but it doesn't say this is the core of the contract. And the severability clauses tell us what is the core of the contract, and they tell it very frankly. There are three of them, and there's no question as to what the intent was. So this is not a situation where, just like the one in Gessa Schatz, the provisions somehow subsume the entire contract, things had to be rewritten. This is much more like a state of duress, which in fact cited approvingly to the Altera versus Bryant case, where the trial court actually took a pencil through the provisions that didn't work and said the rest of this is workable.
But it seems to me it's the Supreme Court of Florida that determines what the essence of an agreement is. I mean, when you read the cases, they don't just come right out and say it in a small way. They go into great detail about this being, the meat of the agreement, so to speak. And so it seems like it doesn't matter what you put in your agreement, the Supreme Court will tell us whether it's the essence or not.
The Supreme Court, Schatz and Gessa have been fairly, I think, limited applications from the appellate courts. First of all, we have had decisions since Schatz and Gessa saying that a limitation on damages is not going to automatically invalidate the entire agreement, and that Schatz and Gessa don't stand for that proposition. Now, certainly, as Your Honor, Judge First pointed out, you have these cases from the 5th District where they were very unsure. And first of all, I believe those cases don't even talk about the language of the agreement, so they're of no help. But they're unsure of what they mean, and for whatever reason, the court didn't find it important enough to take review on this question, which I think is at least, of course, we can read into it all we want, but it's leaving these decisions post Schatz and Gessa intact, which say...
So if we were to affirm, would we need to assert conflict in the Yetta case?
Absolutely not, Your Honor. I think if this was a situation where where the court had cited the language and we could somehow compare and decide there's a conflict, yes, then there would be conflict. But when the court the court went up on an issue of great public importance, not conflict. So even the Yetta case didn't find a conflict with what it was holding, even though...
Well, there was no conflict yet. I'm saying if we affirm, doesn't that create a conflict with Yetta?
Well, the reason I believe Yetta, and the reason I believe it's significant that Yetta didn't cite a conflict is because we do have cases such as LTC-SP, this is the second district decision, and a state of Duresh, which have already found that limitations on damages can just be cut out of the contract.
In the argument that, well, I think Hawkbaum, I think, was just attorney's fees, and State of Duresh was just punitive damages, and counsel for the other side is saying, well, if maybe one standing alone, but if you have a couple of them,
That's
the essence of the agreement.
No court has held that, and so we go back to Judge May asks, well, is this always going to invalidate a contract now that we have Schatz and Gessa? And the answer is clearly no. The courts, at least the second district and this court, a panel of this court since Schatz and Gessa have held that Schatz and Gessa are limited to their facts. Gessa, we had a punitive damages provision with no severability clause, and of course we had the all-encompassing AHLA provisions, which the Supreme Court really focused in, particularly in Schatz, and said this is a situation involving rewriting. We don't have that here. Again, what we have is a very simple clause that sends everything to the arbitrator, and the arbitrator is capable of determining the rest of this, but this is what the U.S. Supreme Court has said, and even if we didn't go to the U.S. Supreme Court analysis, this court can very easily distinguish Schatz and Gessa and find that the severability provisions and the wording of the entire agreement allow the rest of it to stay intact. It does not have to be rewritten, and that the arbitrator can decide the
What's
rest.
the primary thrust of this agreement?
The primary thrust of the agreement is that arbitration is a cost-effective and speedy way of resolving disputes. That's, when you read the entire clause, that is what I think the essence of that clause, if we had to find an essence, is, because the contract's very clear that the rest of the provisions can come out, but that arbitration is going to get this to a determination quickly and less expensively. So I would submit that that is the essence of the agreement.
It's kind of odd, now that you think about it, is why, when it is the nursing homes and who are saying, you can sever these out and we still want to go to arbitration. Obviously, the limitations on liability, on damages and everything, which are being severed out, are beneficial to them. If you look at Gesa, they talk about, without these provisions, the extent of liability would be open-ended. They can, in this respect, the two provisions constitute the financial heart of the agreement, and you can't, there still remain, the question then becomes, there still remains of the contract valid legal, whether there still remains of the contract valid legal promises on one side, which are wholly supported by valid legal promises on the other. When it's the person who, the party who's allegedly disadvantaged and saying, we're not disadvantaged, we still want the rest of this contract. It's kind of curious that the Supreme Court, or they're saying, well, we can throw them out, because as though the resident here would have not agreed with the contract without those limitations there.
Right. Well, I think
ironic.
Yeah, it is, and I think at least under these facts, any defense counsel for a nursing home would know the law when they move to compel arbitration, and the client has decided that it's still the contract should be in place because it wanted to enter into this contract with the understanding that a jury would not be deciding the case, and it would go through the arbitration process. So there is some irony in it, but I think at this stage, with Schatz and Gessa on the books now for 6 years, that both sides can make decisions on whether or not to go forward with this, and obviously, many of the nursing homes still are. So unless your honors have additional questions, we would ask that it affirm the trial court's order. Thank you.
Thank you, Your Honor. I appreciate it. I just have a couple extra minutes here. I'd like to start out by addressing Judge Forst. You asked Ms. Stein whether you would have to certify conflict if you affirm, and I believe that you would. I don't think there is any way around that. We know from the opinion in Nuvista and Rheinchegen 3 main things. There was an arbitration agreement that had a limitation of liability, precluded punitive damages, and had a severability clause. And the court said, GESA is controlling here, it applies, these are not severable, and we're not going to compel arbitration. And I think that any opinion from this court would essentially be the same, and you would have to certify conflict. Ms. Stein says there wasn't enough in the opinion. I think that's enough. If you need more, you can certainly, I would ask you to take judicial notice. If you feel like you need some more, confirmation of that, take judicial notice of the briefs and the record in that case. You can do that, and I can file a formal motion after this, but I don't think it's necessary. I think if you need it for your own consideration, but on the face of the opinion, if you affirmed, it would be in direct conflict with both of those 2 cases from the 5th DCA. Ms. Stein mentioned a couple of cases, including a case called a bunch of initials, LTSP. In that case, to say that the courts have since GESA and Schatz found that certain provisions were severable. That case, LTSP, the court doesn't even say, there's one provision, a limitation of liability, and the court doesn't even say which one. So here we have 2. We already know from Duresh that, a finding of just punitive damages, precluding punitive damages could be severed. But so I don't think that those cases cited are controlling here. A couple of other quick points.
What exactly did the judge decide, other than to send it to arbitration? Because I just reviewed the transcript while we're sitting here, and it's not really clear to me.
It was not clear to me either, Your Honor. I mean, the court, it wasn't clear. There was some discussion of Buckeye, but then the court seemed to recognize that Buckeye didn't apply because we weren't challenging the contract as a whole or the formation of the contract, such as if we would have said that the Ms. Obolensky didn't have the capacity to sign any agreement. That's the type of thing that Buckeye dealt with. So that's different. And I think the court recognized that and then ultimately just said, well, the Supreme Court's already said no limitation of liability, so
It doesn't say anything about anything else.
Well, the court said he was going to sever it. It could be severed because the provisions were in separate paragraphs. The limitation of liability was in a separate paragraph from the arbitration.
Was that the only thing that he found?
It's my understanding that was the basis. The ultimate basis was that Supreme Court's already said these provisions are bad. We can sever them and send it to the trial or send it to arbitration.
Doesn't say anything about punitive damages, though.
He doesn't. He talks about the limitation of liability provisions, which I think encompasses both of those. He didn't address any of the other arguments that we'd raised. Mr. Schuler mentioned, hey, what about the discovery? But we'd also raised the attorney's fees issue. He said he wasn't going to strike through anything else, even though there are already courts finding that the attorney's fee provision, the waiver of the right to appeal are all invalid provisions, and he didn't strike through any of those. He just sent it to arbitration. One final thing, and I think it also goes to the point of what you're going to do with this case, is that obviously we would like to reverse, but even if you affirm, if you could write an opinion, because these cases are still coming up. And I think that's especially noteworthy because, as Ms. Stein pointed out, Schatz and GESA were decided in 2011. This agreement was entered into in 2014, and they still have provisions, multiple provisions, which multiple courts have found since back in 2005 and 2006, violate public policy. And they're still putting them in, these nursing home agreements. I don't know, hoping they slide by. I don't know what it is, but they're still out there. And so I think that any decisions we could get clarifying would be helpful. And so we'd ask that you reverse the order compelling arbitration.
Thank you both. Court is adjourned for the day.